All right. Welcome, everyone, to our webinar on how the new digital and consumer laws impact your business. It's great to see you all here today. My name is Harmanjot, and I'm a senior associate in our corporate and commercial team here at LegalVision. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email, so there's no need to frantically take notes, but of course, feel free to do so. You can submit your questions in the Q&A box and we'll answer them at the end. And if you've got a moment, please complete the feedback survey after the webinar. It helps us ensure that we're keeping our webinars relevant and interesting for you all. For the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. If you provide your contact details in the survey at the end of the webinar, a member of the team will reach out and we can talk you through some of your legal needs. So today we're going to be talking about the Digital Markets Competition and Consumers Act. We'll talk about what it is, what its impact is on your business, who's actually going to be enforcing the new legislation, and then we'll run through some practical tips for compliance before we go through your questions together. Before we begin, you'll see a quick poll question pop up on your screen. This will help us ensure that we're keeping the information relevant to your needs. So what is your main concern about the new digital and consumer laws? Is it that you want to understand how the changes apply to your business? Do you want to ensure compliance with the new legislation? Do you want to adjust existing policies and practices, avoid penalties and enforcement actions? Or is it kind of all of the above and you just want to know everything there is to know? We'll give you a moment to answer that poll question. Okay, we've had a few answers come through, and it seems that everyone is kind of pretty evenly split. The top three priorities seem to be ensuring compliance with the new legislation, adjusting existing policies and practices, and understanding how the changes apply to your business. That's great. So we'll talk through all of those things today. And if you've got any questions, like I said, pop them in the box and we can chat through them at the end. So, the new Digital Markets Competition and Consumers Act 2024, otherwise known as the DMCC Act, is a new piece of landmark legislation introduced into the UK last year. Whilst it was enacted in 2024, its provisions are only now starting to come into force, with the first changes coming into force on 1 January this year. We don't have exact dates for all of the changes coming into force, so you'll need to watch this space for some of them. The DMCC Act strengthens the Competition and Markets Authority's power and indicates a shift towards greater accountability for businesses engaging with consumers. The purpose of the legislation is to protect consumers, and it does this by giving the CMA significant new powers, including to issue businesses fines for any non-compliance and introducing new rights for consumers. So let's dive into it. What are the changes and what do they actually mean for your business? So the first is strategic market status. The new legislation establishes the concept of strategic market status and gives the CMA the power to designate certain tech companies with dominant positions in digital markets as having strategic market status, or SMS. These companies will face tailored codes of conduct and increased scrutiny to prevent market abuse and encourage competition. This was one of the changes that came into effect in January this year. The goal here is to ensure that these powerful players treat customers and businesses fairly. Now, this change won't affect small businesses as it is targeted to those big companies who have a big effect on their market. Before designating a tech firm with SMS, the CMA will conduct an investigation during which they will consult with relevant businesses, their potential customers, and other industry stakeholders. During the investigation, the CMA will assess whether the tech firm they are investigating has substantial and entrenched market power in a particular digital activity. If the CMA designates a business with SMS, the CMA can impose codes of conduct on that particular business, and they can design and impose specific pro-competition interventions, such as new data transfer obligations. Businesses that are designated with SMS will also have enhanced reporting obligations in relation to any proposed mergers or acquisitions. Each designation of a business as SMS will be reviewed every 5 years by the CMA. Now, the CMA has already announced their first couple of SMS investigations, and currently they're in relation to Google and Apple. In respect of Google, the CMA is investigating Google's search and advertising business, which accounts for more than 90% of all general search inquiries in the UK. In respect of both Google and Apple, the CMA is investigating each business's respective mobile ecosystem, which includes their operating systems, app stores, and browsers that operate on mobile devices. The CMA has indicated that it's unlikely to launch a third investigation for at least about 6 months to ensure that it's managing its resources in an effective manner. For most of you, like we touched on earlier, this SMS change won't have a lot of impact, but it's always good to know what the current priorities are and what's happening in the industry. So the next change is unfair commercial practices. This part of the legislation is intended to come into effect in April this year, so it hasn't quite gone live. It makes it a criminal offence to engage in unfair commercial practices. The DMCC Act sets out a list of commercial practices that will always be considered unfair. Whilst this previously existed under the Consumer Protection from Unfair Trading regulations, this new list has been amended and expanded in scope. It's also important to note that the Secretary of State has the power to amend the list of unfair commercial practices, meaning that it will be a lot easier to amend or add to this list in the future, and we can probably expect to see some ongoing changes in this space in response to changing market conditions. The list of commercial practices that will always be considered unfair is quite long, so we're not going to go through it all today, but there are a couple of important additions that I think we should chat about. The first is in relation to fake reviews. It will now be an unfair commercial practice to submit a fake review or commission or incentivize any person to write or submit a fake review, offer or advertise to submit, commission, or facilitate a fake review, publish consumer reviews in a misleading way, for example, giving greater prominence to positive reviews over negative reviews, uh, and publish or provide access to consumer reviews without taking reasonable and proportionate steps to ensure that the reviews are genuine, do not conceal where they have been incentivized, and are not presented in a misleading way. The CMA has recently concluded an investigation into Google, as a result of which Google has given legally binding undertakings to the CMA that it will take a number of steps in an effort to ensure ongoing oversight of reviews and to remove fake reviews. It's important to note that these obligations apply to both businesses who the reviews are about, as well as any intermediaries that are publishing the reviews, such as search engines like Google, online marketplaces, and social media providers. Another commercial practice that is under scrutiny under the new legislation is drip pricing. Drip pricing is where only part of an item's price is shown during the early part of the consumer journey, and the total amount to be paid is revealed at or near the end of the buying process. By this time, the consumer may already feel committed to the purchase, and so despite the increased price, they may be forced to go ahead with the purchase. This means that where a trader wants to give pricing components, they also need to give a total price, which includes all mandatory charges. This also applies to products or services which are for a fixed period of time. For example, if a gym advertises a membership at a fixed monthly price for a minimum term of 6 months, they also need to advertise the total price that will be payable by the consumer over the 6-month term, as that will be the total price for the service. Some other practices that will be considered unfair in all circumstances are misleading consumers as to the availability of a product at a particular price or for a limited duration, promoting products via paid ads without making it clear that the promotion is a paid ad, promoting a product similar to a product made by a particular manufacturer in such a manner that misleads the consumer into believing the product is made by the same manufacturer when it's not, establishing, operating, or promoting a pyramid scheme, including a direct appeal in an advertisement to children to buy the advertised products or persuade their parents and other adults to buy the advertised products for them. The next change is in relation to subscription contracts. So the new legislation introduces significant reforms. They haven't taken effect just yet. The government has indicated that they will likely take effect in spring 2026. We don't have a final date. From a business perspective, this does mean that you can prepare early. You've got some time now to get yourself sorted, but it will likely also mean that there won't be any leniency for non-compliance once the new rules do come into effect. Businesses providing goods or services on a subscription model will need to provide pre-contract information to ensure that consumers can make informed decisions by understanding the nature of the contract and how to terminate. Offer a 14-day cooling off period, both at the time the subscription contract is initially entered into and following each renewal, where the renewal commits the consumer to a further period of 12 months or more. Issue regular reminders to consumers regarding their rights to terminate and when the subscription will renew, and provide simple and clear methods for terminating the subscription. Businesses will also need to notify consumers before the end of a free trial or a low-cost introductory offer. The legislation mandates the pre-contractual information that will need to be provided, and this includes, but is not limited to, the amount and frequency of payments, charges after the trial period, if there are any, the minimum total amount payable, what the automatic renewal mechanisms are, what the termination process is, and what the notice periods and cooling off rights are, as well as information on how reminders will be sent. So that's a pretty substantial change for anyone that engages their customers via a subscription contract. It obviously means that you need to be making sure that you're providing your consumers with all of the information upfront, and then again each time that their contract goes to renew. And it also means that there is a greater risk that your consumers can terminate their contracts despite any auto renewal mechanisms, because they do have that 14-day cooling off right after each automatic renewal, where the new renewal period is for 12 months or more. Okay, so the next change that we're going to talk about is to consumer savings schemes. The legislation introduces protections for consumer savings schemes. So these are schemes where consumers make payments as a form of saving for goods or services to be supplied by the business at a later date. So, for example, Christmas savings clubs or layaway plans. In such instances, the business will have to mitigate the risk of potential loss to the consumer. For example, in the event the business were to become insolvent, and they have to do this by setting up either an insurance policy or a trust arrangement to ensure that consumers can be repaid for their any amounts that they've put towards this scheme in the event that the business does go bust. There are also some changes to alternative dispute resolution rules. So any provision in a consumer contract relating to alternative dispute resolution procedures will be prohibited if the nominated ADR provider is not accredited or exempt under the legislation. So this just means that where you are nominating alternative dispute resolution as your disputes provision within your consumer contracts, you need to make sure that you are directing your consumers to a body that is appropriately qualified and accredited by the CMA. There's also some changes to competition laws. So the legislation introduces a number of changes and regulations, including broad duties to notify of potential mergers. We won't go into that today, but there are some that mostly relates to mergers of a higher value. So who's actually going to be enforcing the new legislation? One of the biggest shifts in the new DMCC legislation is the new enforcement powers that have been granted to the CMA. The CMA can now investigate and impose various enforcement measures on businesses and individuals who breach the consumer laws. The CMA can resolve investigations via undertakings or by coming to a settlement with the breaching business. An undertaking is a legally binding commitment offered by a party to modify its practices to address the CMA's concerns without admitting to any wrongdoing. A settlement, on the other hand, is where a party admits infringement and agrees to a streamlined enforcement procedure in exchange for a discount on any penalty. The CMA can also impose monetary penalties for consumer law breaches. These monetary penalties can be up to £300,000 or 10% of the business's annual global turnover, whichever is higher. In cases of continued non-compliance relating to administrative or consumer law breaches, so for example, where the business has failed to comply with an undertaking or settlement that they agreed to with the CMA can also then impose daily penalties of up to the greater of £15,000 or 5% of daily global turnover. So, daily global turnovers can be quite a significant amount there. Individuals who are an accessory to substantive consumer law infringements may personally face fines up to £300,000. This captures directors or senior managers of businesses, but could also capture other individuals, as the definition of an accessory is quite broad within the legislation. So, what do you actually need to do, and how do you actually comply with this new legislation? The first step would be to review your existing customer journey. Ensure that your marketing is clear and it doesn't have any false or misleading claims. Ensure that your pricing structure is clearly set and the consumers are aware of the total price they will be paying for your goods or services. Ensure that you're providing the required pre-contractual information to your consumers, and consider whether your existing practices are sufficiently transparent and fair. So have a think about your customers and what it actually looks like to interact with and transact with your business. Have a think about exactly what they're seeing when they receive any of your marketing material. Have a think about what they're actually receiving when they're undertaking any contract negotiations with you. Do your contracts currently meet the requirements of the legislation? Are you making sure that everything you're being completely transparent about the services that you're offering, the price around them, and the terms of contracting with you? And then have a think about who else is involved in that customer journey. So if you are using any paid promotions, for example, influencers, make sure that they are clearly identifying where a promotion is a paid ad, clearly identifying whether there are any terms and conditions that relate to a particular promotion that you might be operating. And like we talked about earlier, it is now up to a business to ensure that their influencers are making it clear that a promotion is a paid ad. So have a look at your contracts with your influencers to make sure that those provisions are in there and you're placing those obligations on them as well. And then have a look at your existing consumer reviews and ensure that they are all verified and accurate. The draft guidance published by the CMA doesn't set out exactly what will be considered reasonable and proportionate steps to prevent the publishing of fake reviews, and this will be determined on a case-by-case basis. However, they have set out some steps that businesses should consider taking. So just some things that you can do when you are assessing your current existing reviews and your customer journey. Have a think about conducting regular risk assessments and internal evaluations on the reviews that have already been published, whether that be on your website or on any search results reverted by Google when you Google your business name. Have systems and processes in place to proactively identify, investigate, and respond to or remove fake reviews. Provide third-party notification systems to enable third parties to report content or activity that might constitute a fake review. So for example, if you publish your reviews on your website, have a mechanism that allows users to report reviews to you so that you can verify their accuracy before you leave them published on your website. And also think about applying sanctions to dissuade, deter, and prevent users engaging in fake review-related activity. And of course, I guess the obvious one here is to make sure that you're not actually engaging anyone to publish fake reviews on your behalf, because that could result in significant fines both for yourself and for the person actually publishing the fake review. Generally, You should have your consumer contracts reviewed by legal professionals to ensure that all pre-contractual requirements are being met and to ensure that there's nothing in there that could potentially be considered unfair. Now, like we touched on earlier, the list of unfair commercial practices is quite lengthy. We haven't gone through all of them on this webinar, but a legal professional can, of course, talk you through what they all are, and whether there's any that your business is at risk of, non-compliance with. It's also important that you train your staff on these changes and what they mean for your business. It's important that everyone across your business understands the obligations your business has and the role that they play in ensuring that these are met. If you operate a business selling goods or services on a subscription basis, ensure that you have measures in place to meet your notice obligations when they come into effect. So that could look like an automated system that sends out automated emails when your consumer contracts are due for renewal. Remember, if you don't give that notice, you are in breach of the new consumer laws, and it potentially lengthens the time period that your consumers have to cancel, so that cooling off period there. You should also monitor just generally the market for further news about specific aspects of the legislation and when they will come into effect. As we know, different parts of the legislation are coming into effect at different times. Specifically, an important one to watch will be the changes on subscription contracts, because as the government has indicated, that will likely come into play in spring 2026, but we don't have an exact date just yet. Finally, the legislation is very complex. We'd strongly recommend that you seek legal advice about how the legislation applies specifically to your business and seek some assistance with getting your documents updated so that you have the peace of mind that you're completely ready to go when that new legislation and each of its provisions come into effect. All right, so that does conclude the main part of our webinar. We have a new publication on the UK digital and consumer law changes that you might find useful, and you can download it by scanning the QR code on your screen. We've also got another event coming up next month. You can join us on our webinar on navigating retail disputes, strategies for resolution. That's on Tuesday, the 4th of March at 11 a.m. Now, we will answer your questions shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers and for all of your business's usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviews, unlimited legal advice consultations, and unlimited domestic trademark applications, registrations, and more. Now, the useful thing about the membership is that if you have any questions on the new DMCC Act, we can, of course, sit down and have a chat about them and give you advice that is tailored specifically to your business. As a LegalVision member, you won't worry about the costs of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all of the business's usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about how the membership can help you, request a free consultation when the survey appears at the end of the webinar. Okay, time to answer some questions. Okay, do you need business insurance as a startup? Yes, you will need insurances as a startup. What insurances you need will depend on the type of business that you operate and the goods or services that you actually provide. So an insurance broker would probably be best placed to advise you on what insurances you need. Does the CMA have to issue proceedings against us in a court before they can issue a fine? So that's actually a really good question. With the new legislation, the short answer is no. The new powers under the DMCC Act mean that the CMA can launch an investigation and undertake enforcement actions, such as entering into undertakings or coming to a settlement or issuing a fine, or without issuing proceedings in court. Is there a transition period to comply with the legislation? So As we know, different provisions come into force at different times. And when they come into force, businesses are required to comply. There's no official transition period that's been announced. And given the long lead time on some of the provisions coming into effect, for example, the changes on subscription contracts aren't coming into effect in um, until spring next year. So it's quite unlikely um, that it, that there will be some sort of transitional period offered. So if you've got any more questions, we've still got a couple of minutes left, so feel free to send them across and we can answer them while we're here. Someone's asking whether you will receive a copy of the recording. Yes. So a copy of the recording will be sent to your email. Okay. I think that's about all we've got today. So it was lovely to chat with you all. If you have any more questions, we would be more than happy to chat through them in a consultation with you. You can put your details in at the end of the survey, and we can answer any questions that you have then. While this is a free webinar, we do value your feedback, so we'd really appreciate if you do complete the survey that pops up at the end. Thanks so much for joining us.